Hello everyone, welcome back to my channel, Now I Know My Rights, a channel and a platform dedicated to teaching you your rights. Today's presentation is about how to win a lawsuit in small claims court. Small claims court is the people's court. You get a chance to go in, meet the judge, and tell your side of the story. It's for everyone. You don't have to be a US citizen to file or defend an action in small claims court. As a matter of fact, over 4,000 cases are filed on a daily basis in the Los Angeles area alone. However, as swift, as inexpensive, and as simple as it is, it won't work if you have not done your homework. Small claims court is not like the court that you see on TV. Reality TV court shows, they are all centered around drama. In real court, there is no room for drama. Real court is about facts, law, and evidence. If you are filing a lawsuit just out of revenge and anger, I urge you not to do so, because a judge will see right through it and you'll be disappointed with the outcome. If you take one thing from today's presentation, it should be this. At small claims court, check your ego at the door, and even if the law is on your side, be reasonable in your demands. Without any further ado, let's start today's presentation.
The top 10 tips to win a case in small claims court. The following is a step-by-step guide on how to increase your chances to win in small claims court. Small claims court should never be your first option. Always try to resolve any dispute amicably without resort to litigation. However, if you can't reach an agreement, it's a good practice to send a letter by certified mail demanding payment of your losses with a deadline to respond. Sometimes this demand letter is required by law before you can file a claim. If the dispute is not resolved amicably, proceed with the filing of your lawsuit. Keep in mind that if you lose your case, you can't appeal it. Only a defendant can appeal a small claims court case. Plaintiff has one chance, so it's very important to prepare a case to prevail. 1. The Statute of Limitations. Before you file a claim, check the applicable statute of limitations in your jurisdiction to make sure that your claim is not barred by time. If you file a claim beyond its statute of limitations, the defendant could file a motion to dismiss. The following deadlines apply in California, but many states have similar deadlines. The statute of limitations in personal injury cases is 2 years from the date of injury, and if the injury is not immediately discovered, it is 2 years from the date it's discovered, or it should have been discovered. For breach of oral contracts, it is 2 years from the date the contract is broken. For breach of written contracts, it is 4 years from the date the contract is broken. In cases for fraud, it is 3 years from the date you discover the fraud. For property damage cases, it is 3 years from the date damage happened. For cases against a government entity, you are required to file a written claim within 6 months of the incident with that government entity. Therefore, it is very important, as you see, there are different statute of limitations for different causes of action. Check the statute of limitation before you file your claim. 2. Filing the requisite paperwork. Once you've made certain that your claim is not barred by a statute of limitations, go to your county's clerk office and get the paperwork to fill out the basic information about your case. The papers are called summons and complaint. When filling out the paperwork, pay close attention to all procedural requirements. One such matter is naming the right defendant. You must correctly identify the responsible party or parties and sue them by their complete name. This is a very important step, and you'll be surprised to know that it is often overlooked by people. It is important because when you win, you can only collect from the party or parties whose name is exactly the same as the name that appears on your claim. Therefore, if you are suing an individual, write his or her first name, middle initial, and last name. If you are suing a husband and wife, write the husband's full name and followed by the wife's full name. If you are suing a DBA, which stands for doing business as, insert the letters DBA between the name of the owner and the name of the company. If you are suing a partnership, name both the partnership and the partners. If you win, you are entitled to collect from either the partnership or the partners. If you are suing a corporation, write the exact name of the corporation. 3. What is a proper venue? You have to decide which county is the proper county to file your claim. This is called venue. For example, if you are involved in a car accident, the proper venue lies with the county in which the defendant lives or where the accident happened. In a breach of contract claim, proper venue is where the contract was formed. All counties have advisors who can help you to determine the proper venue. If you file in the wrong venue, defendant can file a motion to dismiss. 4. The amount of your claim. You must indicate the exact dollar amount that you are suing for. Check each jurisdictional limit. In most states, it is $10,000 for natural persons and $5,000 for corporations, partnerships, and government entities. 5. Service of process. Now that you filed your claim with the court, you have to notify the defendant or the defendants that they are being sued. This is called service of process. Check your local rules on service. Follow the rules. Once served, file a proof of service with the court. 6. Settlement negotiations at the court. Before your case is called, the court requires the parties to go into the hallway to try to settle the case. This is one last attempt to come to a resolution before hearing the matter. If it doesn't resolve, you will go back in and your case will be called. 7. Preparing and presenting your case. It is very important that you tell the judge quickly and in an organized fashion what happened. It's a good idea to prepare a chart of who, what, where, and why in a chronological order to explain your case. It's very important that you understand the legal basis of your claim. You might have heard that in a small claims court, you don't need to have any legal knowledge on what type of legal claim you have. Unfortunately, in reality, this is not how it works. At the very basic level, you have to have an understanding of the legal issues because the judge will decide your case on legal rules. The informal format of the proceedings doesn't mean that the legal principles do not apply. Regardless of how articulate, respectful, and organized you are, the law must support your contention that you were harmed or damaged by the illegal actions of another. The facts of your case must fit at least one or two legal requirements of your case. This is called establishing liability. For example, if you are suing for a bad debt, which is a type of contract case, you must prove that the debt exists, its amount, when payment was due, and the fact that payment was not made. For a failure to return a security deposit, as a tenant, you need to prove that a deposit was made, that it was not returned, and that the premises were sufficiently clean and undamaged when you moved out. Once you know the legal elements of your claim, you have to be able to prove it by a preponderance of the evidence, meaning more likely than not. Some refer to this as the 51% rule. Some call it the balance of the probabilities, meaning more likely than not. Even though it's not a high standard, keep in mind that you still need proof. Remember, in legal proceedings, your version of the facts must be supported by the evidence. In order to get a document into evidence, you have to explain to the judge where it came from, who produced it, why you have it, and what it shows about your case. It's important to have documents, bills, receipts, telephone messages, pictures, emails, letters, demands to prove your case. If there are any witnesses, take them with you. Nothing is as impactful as a credible witness testimony. If your witness is available to attend the hearing, take them. If the witness is not available, obtain a written statement and ask the witness to sign it under the penalty of perjury. 8. Never argue with the defendant. Now that you've presented your case, it is defendant's turn to defend himself. No matter how far-fetched and annoying is the defendant's side of the story, don't interrupt the defendant. Don't argue with the defendant. And don't get emotional and excited. Always wait for your turn. Maintain a confident, respectful composure with minimal emotion. Your job is not to convince the defendant. Your job is to convince the judge. When preparing your case, you should anticipate and be prepared to refute what the defendant will claim. This is a very important step. For example, if you are suing a tenant for early unlawful termination of a lease, you should expect a defense that you as the landlord failed to mitigate your damages by not attempting to rent the property on a timely basis. Therefore, it's important that you take evidence of a listing and add, or at the very least, a sign posted on the property to show that you tried to rent the place, but despite your good efforts, it remained vacant for the remaining term under the lease, and thus, defendant is liable to pay. 9. The judgment. The judgment lists the amount of the judgment, fees, and accumulated interest so that you can collect what's owed. Judgments are enforceable for 10 years. They are renewable after the 10 years, although you must renew your judgment before it expires. When you win a judgment, it is clear that the person or the entity that you have sued owes you money and is supposed to pay you. However, first you have to wait till the appeal period expires. As I mentioned earlier, plaintiff has no right to appeal, but a defendant has the right to appeal the judgment. 10. Collection of the judgment. The court's judgment in and of itself won't be enough to initiate the collection process. You have to fill out additional paperwork such as an abstract of judgment. You should also record your judgment to create a lien on any real property that might be owned by the defendant in the judgment's jurisdiction. This way, you can collect upon the sale of real property. Ask yourself if the judgment is worth pursuing. If the answer is yes, then there are a few options such as wage garnishment and bank account levies that are economical to pursue and they yield good results. You can always retain the services of a collection agency if you think you don't have the time or the patience to pursue collection yourself.